think people misunderstand how to go through the divorce process. So if whether you're working with me or you're trying to do your own divorce, I saw this checklist that was pretty simple, and I want to go over it here. I'm going to share this with you. And again, this is for Riverside County, but the process is the same throughout California. Let me pull up my list so I can read this. So it's a case management order checklist. It's not something you have to file with the court or anything like that, but it's just to kind of keep track and tabs of where you're at, and it explains the process. And I thought this was done in a very simple way. They have the court process online, on the websites and so forth, but it can be very confusing. So I'm going to go over how they're explaining things need to be done, and I'm going to kind of on the backside of that tell you how I do things, so you know what to expect if you're working with me. So we filed this new case. This was back in October, and it came with this checklist. And I thought, hey, I'm going to share this. This seems a pretty good way for you to keep track of your divorce and what needs to happen, because people seem to be lost in the process, and they will often not finalize their divorce or not know where they're at in the process or what the next steps are. And this is a checklist for both parties. So you can see here, it tells you the date the petition was filed. The next thing you're going to do is you're going to want to serve the paperwork, obviously, and then has the date response filed if you're going to have a response filed. So here's the instructions here. It says, petitioner, serve the petition and case management order and file the proof of service within 60 days of the petition being filed. So that is the step. Once you file your divorce, the next thing you want to do is serve the documents on your spouse. There's a couple of ways you can do that. You can have it personally served. You can use the sheriff, or as I like to do it, we use a form called notice and acknowledgement. And it's basically just a form your spouse will sign in order to have the same effect as being served. And you'll file that notice and acknowledgement. It's an FL 117, and you'll file that with the proof of service FL 115. So they're saying within 60 days. I think that's a good general rule of thumb with any court in California, because when there's no movement on the case, the different counties have different timelines of when they'll send out a notice of a hearing. And it's basically like a status conference. They want to say, hey, what's going on? Your case isn't moving forward. They want to make sure you know that there's more that you have to do to finalize your divorce. Number 2, serve the preliminary declaration of financial disclosure. This is the 142 and the 150. Schedule of assets and debts and income and expense declaration within 60 days of the petition being filed, and file the declaration regarding service of disclosure of 141. So the 142 and the 150 do not get filed with the court. This is purely for disclosure between you and your spouse. The 141, this declaration regarding service of declaration disclosure, is the only thing that will get filed with the court that says you did do this step. Now, I want to back up real quick and let you know that, like, we don't follow this process. We're not waiting 60 days to turn in the proof of service. We're not waiting any period of time to do the, to do the serving. The disclosure portion, we don't wait for any of that. We compact everything into one step, not all these different steps, because we don't have to follow this process broken down like this. We'll do it in one shot. So for instance, some of the cases we handled this week, hired us this week, we e-filed this week, and we finalized all their paperwork this week. Now, there's certain timelines that we have to wait. Usually we're backed up against when we can turn things into the court versus we have to do it within a certain time period because we're moving the cases through the process so fast. So for instance, after we file and then the spouse signs the notice and acknowledgement and starts the clock on the 6 months, it also starts the clock on when we can turn in your final paperwork for review, and we can turn those in 31 days later for review. And again, if it's a court that has a huge backlog, that's a benefit because you're still in that cooling off period, and you're waiting for the 6 months to pass, but your paperwork's already in line for being reviewed. Responses due 30 days after the party is served with the petition. So the only comment I'll make on that is the response is not necessary if you are going through an amicable divorce. We never have our clients file the response because it's not necessary. There's several processes you can go through, procedures. There's default with agreement, default without agreement, and uncontested. And the difference is procedural in nature only. So when you file a response, it's actually considered an uncontested case. It's not a contested case until you go to court and see a judge. So in this case, no response would need to be filed if you guys are amicable. I think it's interesting that The courts they're not saying that there's these different options. If you Google it or you watch my videos, you'll understand that there are different processes. And you know that I follow the default with agreement purely to save people money, because when a lot of people don't know is when you file the response, it triggers a $435 fee again. So it's just a money saving device for us. It's not wrong to file the response, but they're not giving you that option here in this checklist. They're saying responses due, file your response. I think the courts want their money. I get it. They keep jacking up the rate. When I started doing this 12 years ago, I think the filing fee was like $285 or something like that, 295, and then just keeps going up, and now it's 435, and if you e-file, it's 465. So that keeps changing. Just on this topic, response is not required if you guys are amicable. A lot of people will hire me who have started their own divorce, and they'll follow a checklist like this, or they'll just read the rules, or even on the summons says you've been served, you have 30 days to file a response. If you haven't been doing this as a business like I have, you're going to say, oh, shoot, I got to file the response. So a lot of people will come to me and they've already filed the response. I'll tell them it wasn't necessary. It's not wrong, but it's just a kind of waste of money. Okay, if a response is not filed within 30 days after the petition was served, file a request to enter default 165 within 60 days after the response was due. So that's not a hard timeline in any court, even with Riverside. You don't have to do that. I think they just want to move your case forward. There's no rule in California that says you have to file the default within 60 days after the response was due. We don't file the default just alone by itself. A lot of people do because that's what the checklists say. You don't have to file it as a single document. Here's how we do it with our clients. We do the initial petition, we get it filed, we get a case number. We then, once we get our terms from our clients, we draft their settlement agreement and all final documents. They sign it and and everything's done. Signed, sealed, ready to be filed. Once we can file, after that 30 days have passed, or 31 days have passed, we submit that to court with the request to enter default, with the FL 141 disclosure declaration regarding service of disclosure, with the proof of service. We don't do it in these broken down steps like they do it. We do it all up front, and then we turn it all in one go. And the benefit of doing that is the court gets initial filing, and then they get a packet, or in case of e-filing the judgment like in LA County, we submit everything. So when the clerk receives what I consider the judgment package, they have everything. They now open the file and they go through everything in one shot, as opposed to them having to keep the clerk going in and receiving these filed documents. They're actually being reviewed and filed simultaneously, and that's how we get faster approvals when we submit these to court. Next, file default judgment paperwork within 60 days after the request for entry of default is filed. So again, that's not a hard timeline. And again, we would do that. We wouldn't do these in two separate steps or even 4 or 5 different steps. We do this all in one shot. But what I don't like that I'm saying here is file default judgment paperwork. They're not letting you know that there's 2 types of default with and default without agreement. And this is a huge issue for me and for you if you're trying to go through your divorce. And let's say you file for divorce, you serve your spouse, and they're not in agreement, and they're saying, okay, well, you file the default, and then turn in your default judgment paperwork, and they're referring to default without an agreement. So you're never going to get a default without an agreement through the court. They're highly technical, challenging. There's a lot of rules involved with them, but they make it seem simple. And then you turn it in, you get the rejection, and that's when people call me and say, Tim, I've had my divorce rejected, a half dozen times, and I can't get it through. And it's because you're trying to do a default without an agreement. For the respondent, file your response, FL 120, within 30 days after being served, and file the proof of service. Again, a response is not required if you have an amicable divorce. We don't have our clients file their response, but again, it's not wrong to serve your preliminary declaration disclosures. So same rules within 60 days, and that actually is a correct rule here, both for the petition. For the disclosures for both petition and respondent to be filed within 60 days. But if that's not done, and you're amicable, the court's not going to say, hey, where's your disclosures? You haven't filed these within 60 days. They don't keep that type of track of your case. It's just for you and your spouse to know, to keep your case moving. If you were going through like a contested divorce, or you had attorneys, and say one spouse has not complied with the 60-day rule, your attorney would write a letter to your spouse's attorney and say, hey, this was due in 60 days. If you don't get this done in a week or 10 days or whatever extra time they give you. We're going to file a motion to compel or take you to court or whatever. So there's a way you can resolve that. But like for my clients, let's say you start off, you're amicable, we file, and we don't follow this process, the court's not going to have an issue with it. This issue is just for you guys to know this is the general rule. But sometimes we'll have clients that are going through mediation. We filed, they're going through mediation, they haven't done the disclosures yet, they're still in mediation for months or whatnot, and then they will we'll go way over the 60 days, and it's not an issue unless you have an issue with it. You could go to court and say, hey, they haven't filed their disclosures, but we're not dealing with that because all of our clients are amicable. So file a response, serve the disclosures. If a response is filed, petitioner and respondent should work together to reach an agreement on all the issues in their case. You may be able to resolve the issue in your case without court hearing or trial through alternative dispute resolution or collaborative law. So our clients don't go to court. We don't. They're making an assumption here, or they're leading you to believe here that there's no response, there's no agreement, and that's absolutely incorrect. That's how I'm reading this, and that's how you would probably interpret this. If there's no response, there's no agreement. Default with agreement is the way to go. So you can still have this written agreement just without filing the response to save yourself some money. I try and harp on that just because there's a lot of people that are like, when they watch my videos, they're like, shoot, Tim, I just saw your video and I just filed my response yesterday, and then I saw your video that it wasn't required and you're amicable. So yeah, again, our clients don't go to court. You don't need to go through a dispute resolution, or I guess I could consider myself an alternative dispute resolution type service, or a collaborative divorce service. I have a neutral third party. I work for both of you to get you your paperwork through the court without a hearing. So yeah, court is not required. You can reach an agreement, don't need to file the response, and we do default with written agreement. If no agreement is reached, file a request for a settlement conference and trial. So there's different forms for that for different courts. In LA County, it's called a trial setting or request for trial setting. So there are forms, different forms for different. This is Riverside. So don't, unless you're in Riverside, don't use this form. Different forms to get the court to help you out, basically. So when I have consultations and people say, Tim, we're not in agreement, and we only work with clients who are amicable and going to reach a full agreement and sign off on everything. And I'll tell them, if it's not moving forward, and the court's not going to get involved until you ask them to. And the way you do that is by filing a settlement conference request or a trial setting request or whatever your county's request is. That's the only way you can let the court know, hey, we're having problems, we're not in agreement, here's the issues. They'll basically bring you in, say, what's the issues? You explain to them, and then the court will put you on a path to get your divorce finalized, whether that be through mediation within the courts or eventually possibly leading to trial. Final judgment submitted no later than 18 months after the petition was filed. You have technically 5 years to finalize your divorce. I've finalized cases that are 25 years old. The court can at any time dismiss your case for lack of what they call lack of prosecution or not moving forward. I've seen some dismissed unilaterally by the court after just a year or so. If there's hearings that are set that you don't appear at, they can do that. But in many times they don't do that. Some of the courts set automatic hearings, like off the top of my head, Ventura sets like 3 automatic status conference hearings. I think San Diego does 3 automatic, and I think the first one's out like 6 months, 8 months, something like that. But basically by that time, it's going to send a note to the clerk. There's going to be a hearing. You're going to get a notification. You're supposed to appear. Most of them are by Zoom, or they'll call you, like in the case of San Diego. But it's just for them to say, hey, here, they open up your file. Here's where you're at. What's the status? What's going on? They'll make notes. And then if you still haven't finalized your divorce by the next hearing, again, there'll be another status conference hearing. LA County doesn't do that. They don't set status conference hearings unless they're not automatic. Like when you file, like I was saying, Ventura and some other courts as well, you'll get automatic 3 hearings or so. LA County doesn't do that. Their LA County's hearings are triggered by a lack of movement on your case. And there's no hard and fast rule, but it appears that when, say, your proof of service isn't filed within 60 days, it'll trigger a notice for a status conference to appear. And it basically says, your divorce is not finalized. If you file your that we're calling you in for a status conference. If you file the proof of service before the hearing date, you don't need to appear. Again, they're just trying to move your case forward. So I just wanted to share this with you.